Let's take a look at a key criminal law case. This is the case of R v Woollin, 1998. This is a key case because it is the current authority upon the topic of indirect intention. First of all, to have a look at the facts. In this case, the defendant had lost his temper with his 3-month-old son. He threw him onto a hard surface, and this caused the child to die following a fractured skull. The defendant was originally convicted of murder at trial. Whilst it was accepted by the Crown that the defendant did not desire to kill or cause serious harm to his son, he was prosecuted upon the basis that he indirectly intended it. At the trial, the judge gave the direction of intention that the defendant has the relevant intent if he realised by his actions that there was a substantial risk that he would suffer serious harm. The defendant then appealed to the Court of Appeal upon the basis of this direction, claiming that use of the term substantial risk was an error and that there should not have been guidance given to the jury. The defendant appealed to the Court of Appeal, who dismissed his appeal, so a further appeal was made to the House of Lords. The House of Lords, whilst finding the defendant guilty of manslaughter, not murder, gave us the leading judgment upon the topic of indirect intention. They held that the reference to substantial risk, which was given by the original trial judge, was incorrect, and that the definition of indirect intention, which had been established in the case of R v Nedrick, 1986, was the model direction that should be used. A jury should be directed that they are not entitled to infer the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention, as a result of the defendant's actions, and, most importantly, establishing a subjective test that the defendant appreciated that such was the case. In exams, it is useful to think of this as a two-part test for consideration. This case also gave us a really useful quote summarising the topic of indirect intention. In the judgment, it was said, "A result foreseen as virtually certain is an intended result."